What happens when we die? Do we go to heaven? Hell? Do we have a soul? What happens to our soul when we die? Unfortunately, I don't have the answers to those sorts of questions, even though technically I am an ordained minister. But I can tell you what happens in the Commonwealth of Virginia when you die, because I'm Zach Worrell, an attorney licensed in Texas and Virginia. Before we start, be sure to like, subscribe, and click that little notification bell so you never miss an important update and so you can help this channel grow. So, what happens when you die, legally speaking, in the Commonwealth of Virginia? What happens to your assets, your real estate, your personal property, your debts? As with every legal question, the answer is, well, it depends. To start, let's go over a few simple definitions. Your estate is the sum total of all of your property, personal, real, your assets, and your liabilities. And so if you're thinking of dying and that your debt is going to die with you, think again. If your liabilities exceed your assets when you die, whatever can't be covered by your assets, it kind of does die with you, but your heirs will inherit nothing. What are heirs? Your heirs are the people who will inherit your estate when you pass. An executor is somebody who oversees the distribution of your assets according to your will if you have one. And probate is the process by which the court oversees the administration of your will by the executor. Dying intestate means dying without a will, and dying testate means dying with a will. Let's start with what happens if you die intestate or without a will. Virginia Code Section 64.2-200 and 201 direct the disposition of your estate if you die intestate. If you die with a spouse and children only with that one spouse, your spouse inherits everything. If you die with a spouse and children, and some of those children are not with that spouse, all of your children will inherit 2/3 of your estate, and your spouse inherits the remaining 1/3. If you have no spouse and children, your children inherit everything. If you have no spouse and no children, it goes to your parents. If you have no spouse, no children, no parents, then it goes to your siblings. If you have no spouse, no children, no parents, and no siblings, then it goes to your grandparent or grandparents if there are any remaining. If no grandparents, then your aunts and uncles. And if no aunts or uncles, then to the siblings of your grandparents. Effectively, it moves up, over, ad nauseum, unless there are no heirs at all. If one of your parents has no siblings, then everything goes to the other parent's siblings. And if neither of your parents have any kin, then the entire estate passes to your most recent spouse. If that spouse died before you, then that spouse's descendants inherit as if they had died intestate. And ultimately, if there's nobody to inherit anything, then everything passes to the Commonwealth.
It's good to be the king.
When dividing up property according to these rules, Virginia follows a per stirpes allocation. That's fancy Latin for everybody gets an equal share. So, if you have 3 siblings, each sibling inherits 1/3. Then, if one of your siblings has predeceased you, and they have 2 children, your living siblings inherit 1/3 each, and each of your deceased siblings' children receive 1/6, or 1/2 of the 1/3 that they would have received if they had not predeceased you. And for a few more caveats, half siblings or half-blooded relatives inherit 1/2 the share that they would have inherited had they been full-blooded. And if somebody falls into an inheriting class and is born after your death, they inherit a full share proportionate to their amount. Long story short, intestate succession in Virginia can be a big mess, and you have no control at all over the process or who gets what. And so that's why you probably want to have a will. So, let's cover testate succession, or dying with a will. A will is a device that allows you to control to whom your estate passes. You can control specific pieces of your estate. For example, you could say the house goes to Johnny, and the bank accounts go to Sally. You could say, none of my children inherit anything, and everything goes to my grandchildren in equal shares. And in your will, you should appoint an executor, a person who executes the terms of the will to ensure that everything is distributed according to your wishes. In other words, a will allows you to control to whom your estate is distributed upon your death. A valid will has a few requirements. A holographic will is a will that's written entirely in your own handwriting. Every single word written in your handwriting and signed by you. But if any word is not written in your handwriting, you're going to need to have 2 witnesses to your signing the will. And those witnesses need to sign the will as well. These witnesses need to affirm the fact that you signed this will, and you need to witness each of the witnesses signing the will. You don't need both witnesses in the room at the same time. You just need to see each of them sign the document. Substantively, you need to have testamentary intent. That means that you intend that this document serve as your will. You also need to have testamentary capacity. Testamentary capacity means you know what you're signing, you know what your estate is comprised of, you know who your heirs are, and you know how the will functions to distribute your estate to your heirs. You also cannot be under duress, undue influence, or otherwise legally incapacitated. You can keep this will in a desk drawer, but it's a good idea to file the will in the circuit court of the county that you reside. You can also make your will self-executing. What that means is that you don't need to go through hearings and all sorts of stuff to prove that you actually signed the will, or that the witnesses saw you signing the will, or that you saw the witnesses sign the will. To do this, you get a notarized affidavit by you and the two witnesses who say who they are, that they saw you sign, you saw them sign, etc. You can write a brand new will, and it'll displace everything in a previous will that the new will conflicts with. Anything conflicting with the new will and the old will is overridden by the new will, but anything that's not overridden by the new will survives. You can also invalidate a will by physically destroying it, such as tearing it into pieces or lighting it on fire, or crossing out every section of the will. Or if you don't want to write a whole new will and you want to amend certain provisions, you can execute what's called a codicil. A codicil is essentially an attachment to the existing will that explains the new terms. Of course, there are rules that govern the validity of codicils as well. With a will, you can control how everything in your estate is passed and to whom. It prevents the state's rules from controlling to whom your assets go. Your will can even control where your funeral is held, what happens at your funeral, where you get buried, if you get cremated, those sorts of things.
I'm not gonna be buried in a grave. When I'm dead, just throw me in the trash.
Just be sure to get it all in the will. So these are the cliff notes of creating a valid will in the Commonwealth of Virginia. But as always, it's best to consult with an attorney. And that's why I'm offering everybody in my audience a free consultation about your last will and testament if you use promo code AFTERLIFE when signing up for the consult. That said, whether you die without a will and everything passes by the rules of intestate succession, or you have a will and everything's probated according to the terms of the will, there are certain things that you own that will pass outside of either of those processes. Anything with a named beneficiary, such as a life insurance policy, a retirement account, or anything that includes a transfer on death provision, such as your bank accounts, your real estate, your personal property, your vehicles, and things held with the right of survivorship. Let's briefly touch on the different forms of ownership of real estate and the rights of survivorship. I'll save all of the details for another video, but here are the broad strokes. You can own property with another person in three main ways: as tenants in common, joint tenants with right of survivorship, and as tenants by the entireties. Tenants in common each own a divided interest in the whole thing. And so if you and one other person own a property as tenants in common, you each have a divided interest in that thing. If one of the tenants in common dies, that tenant in common's ownership is distributed by the rules of intestate succession or by probate. Joint tenants own a property as an undivided whole. And with rights of survivorship, if one of those joint tenants dies, the remaining joint tenants own the whole undivided. This happens apart from and outside of intestate succession or probate. Tenants by the entireties is a special form of joint tenancy, where the husband and wife own the property as joint tenants, and they have the right of survivorship. Tenants by the entirety survive so long as there's a marriage, so if you get divorced, the tenancy is destroyed. But if one of the spouses dies, the other spouse gets the property in full. And so, as with a will, if you're thinking of buying a property with your significant other or spouse, be sure to get with an attorney to make sure that the deed gives you the type of co-ownership that you're looking for. And for questions like this, as with your will, anyone who signs up for a consult with the promo code AFTERLIFE gets a free consultation. And finally, there's one more tool that you can use to determine how your assets pass when you die, and that's with a trust. I'm going to save the meat of the trust discussion for another video, but just be aware that that's out there. And so while I can't answer questions like what happens to us when we die, whether you have a soul, if you're going to go to heaven, I can answer the questions for you about what happens in the Commonwealth of Virginia to your estate when you die. And so please use promo code AFTERLIFE to sign up for a free consultation today. And as always, if you like this video, please be sure to like, subscribe, and click that little notification bell so you never miss an important update. Thanks for watching. Requiescat in pace.